If you are facing an assault family violence allegation, there's some important things that you need to be aware of. First and foremost, let's talk about how serious family violence allegations are. Even the lowest level, smallest, most insignificant allegations of family violence carry some really important penalties. Number one, if there is an affirmative finding of family violence in your case, whether you're convicted or you get probation, even deferred adjudication probation, you are prevented from owning or possessing a firearm or ammunition. So for a lot of people in Texas, that's a very important right and something that you need to be aware of. Secondly, family violence allegations make cases really sticky. And what I mean by that is, even if you get deferred adjudication probation, it doesn't matter on a family violence case when it comes to getting your record sealed or non-disclosed down the road. For pretty much any other type of case, let's say you get a shoplifting case, if you get deferred adjudication probation and you successfully complete that deferred probation, that shoplifting case gets dismissed, and then you are eligible to ask the court to seal your record in what's called a petition for non-disclosure. The problem is assault family violence cases, even low-level ones, are not eligible for a non-disclosure. So that's something you have to be aware of from the very beginning. A knowledgeable criminal defense attorney who knows assault family violence cases very well should be on the lookout for these things and should be fighting to get the family violence struck at the very least. So these are important things to keep an eye on. Beyond that, um, unlike what a lot of people think, the complaining witness or the alleged victim can't just drop the case. I see this all the time. I end up speaking to the alleged victim on the phone or in a consultation after the incident, and they say, I just want to drop the case. This whole thing was a misunderstanding, or I lied, or whatever, and they want to know what they can do to just make it go away. The sad reality is it is not going to just go away. Now, that's not the end of the story. A good criminal defense lawyer who knows assault family violence can get you a fantastic outcome, but it is oftentimes a lot longer and slower and more frustrating of a process than people want to realize. Uh, Now, there are things the alleged victim can be doing that can really help. One of which is called a ANP, or affidavit of non-prosecution. Now, the mistake most people make is they do a form ANP. What I mean by that is it's just a form of paper that says, my name is, I am over the age of 18 and of sound mind, no one has threatened me or put me up to saying this, and I don't want to prosecute. That is not going to push the needle in any way with the prosecutor. It's not going to force their hand, and it's certainly not going to drop the case. What we do here at the law office of Mike Howard is we thoroughly interview the complaining witness or any witnesses in the case and take down a factual affidavit. So if it's I lied, or if it's this whole thing was a misunderstanding, or I left some important facts out, or now that I have thought about it, I realize that the person was defending themselves against me, or whatever the actual story is, we put that in an affidavit and make it clear. The idea is, as lawyers who know the law and know the defenses to assault and other violence, we, anytime we can, bake those into the affidavit so that that affidavit is as effective as possible. Now, obviously, we're not going to lie. We're not going to ask the complaining witness to lie, but we are going to ask the right questions and word that affidavit in such a way that it is still true, but that it is as effective as possible. So these are things that you need to be aware of in assault family violence cases, and that you need to be asking a knowledgeable criminal defense attorney about to make sure that they are the right fit for you.